What's going on with there's a protest been going on today with Stop ULEZ, and the police turned up to move them on because they were near Sadiq. Well, they weren't even near Sadiq Khan's house. They weren't even that far from Sadiq Khan's house, and they sent a load of police to move them on. No one's quoting the right to petition. They can't actually be arrested or anything under the right to petition. It's only when people are doing protests when they're not using that act and not actually doing petitions. And then the police have just come out with this Section 42. Harassment of a person in his home, right? They're not in someone's home. We've got this Section 42 here, right? Behaviour by a person in another person's home, which is intended to persuade the resident not to do something that he is entitled to or required to do, or something that he is not obliged to. Under Section 42 of the Criminal Justice and Police Act 2001, a police constable has the power to direct a person to move away from another person's home if that person is present for the purposes of harassment. Well, they're not for the purposes of harassment. They're there for the purposes of petitioning. So the police actually have come with the wrong premise. It has to be intended harassment. The intention is to raise awareness of a political campaign to whomever they want, the public or a small section of the public. The section was amended by the Serious Organised Crime Act 2008 as to make an offence for a person when he is subject to a direction to leave the vicinity, to return with a specified period of up to 3 months. The 2005 Act inserts a new Section 42 to criminalise behaviour of broadly the same kind as that which currently enables the police to issue a direction. Well, it's only a direction. If you don't comply with the direction, yeah, but that's not when you're exercising a right. They're treating it as if they're not doing a political campaign and they aren't exercising an enactment, a clause of an enactment which allows them to do it without being prosecuted, which is a 1688 Bill of Rights, right to petition. And there's no restriction for how many people they can have there because the Tumultuous Petitioning Act has been withdrawn. So they've been bluffed. Khan's bluffed them, but he's threatened them with the police and scared them and frightened them. So even if they'd got arrested and taken in, how could they charge them? It's all under the presumption that it's not the right of the subject to petition either Houses of Parliament or the King. And all prosecutions aren't illegal when they are. When you're doing that, this is for anyone or a group of people who aren't engaged in a political action using a political right. And the police should know that. And they're actually lying. This is actually police. This is a corrupt and illegal practice because they aren't actually there. So what if they're near Khan's house? What happens if he's the mayor of a little village, right, and they're doing a petition in the village? Does that mean that they can't actually petition in that village just because he happens to live in the village? Tosh. Absolute tosh. This is absolute, complete and total crime from the police. It's actually criminal. What else have we got? There's quite a few different things. Where a person shall have unlawfully assault or beat any other person, 2 justices of the peace upon complaint by or on behalf of a party aggrieved may hear and determine such an offence, and the offender shall upon conviction therefore before them at the discretion of the justices either to be committed to the common. They just said that you can go up to the common and continue it at the common. It says committed to the common. This is a Section 42, persons committing, this is a different act though, committing an assault, a common assault or battery may be imprisoned or compelled by 2 magistrates to pay fine and costs. 2 magistrates. You need three magistrates in the tumultuous act, and you don't need anyone. It's being revoked, but even then, if it was under 20 people, you didn't even need any consent to do anything. What I'm saying is, they're not doing any assault. Where any person shall unlawfully assault or beat any other person. Well, the police are beating them because they don't know the law. The police are beating them because they don't know the law. This is a corrupt and illegal practice, perversion of the course of justice. Two justices of the peace, upon complaint by or on behalf of the party aggrieved, well, Khan hasn't been beaten or hit, may hear and determine such offence, and the offender shall, upon conviction thereof, before them at the discretion of the justices, either be committed to the common gaol or house of correction. The police have said you can do the protest at the common, but you can't go past Sadiq Khan's. And in this section 42.1 here, out of any act you could have plucked out of the ether, out of thin air, it says committed to the common. This is some sort of joke or wind-up. I don't know who's behind it, whether it is Khan or someone else meddling in between it, but there's some sort of there's some sort of hustle going on. It's almost like the Gales, like Gail Bradbrook, blow me away. They've been blown away. Committed to the common gaol or house of correction, there to be imprisoned for any term not exceeding 6 months, or shall forfeit and pay such a fine as shall appear to them to meet, not exceeding together with costs, if offered, the sum of and such fines as shall be so awarded, together with costs, if ordered, shall be paid either immediately after the conviction or with such period as said justices at the time under the conviction appoint and may commit the offender. Well, the thing is, you've got a large group of people who are all consenting to their own behaviour. They're the peers. So they're making their own judgment of their own behaviour. And even if Sadiq Khan was the mayor, and even if he could hold criminal sessions and make orders on this, it'd be judged by the peers anyway, like in the William Penn and William Mead case. I don't know why it's pulled this act up anyway, but this is I'm trying to find out which section 42 the police officer was referring to. There's a few. This is about assault. There's no common assault here, but they've told them they're telling them to move on to the common gaol, blown away. Common gaol, blown away. Can't be that one. I think it's the one that I just said about being, you got to be in someone's house or near it, and that's just a normal offence of, say, a group of kids or a group of people. It does not apply when you're using an enactment. And the police, and all of the laws that the police are enforcing against all these protests and actions, they're regarding them as if they are just normal people, not using an enactment. And the way that Priti Patel and Rishi Sunak have written the Public Order Act, they refer to it as a protest or a demonstration. It's not they're not acknowledging that this is a petition of signatures of people addressed to the government for an action. They're just, you can have like a demonstration or an action which is not necessarily calling for action from the government. Like, for example, if a fairground closes and throws everyone out, people can protest. For example, if, they're trying to get on a ferry and, the ferry won't let them on and it's going to set off, they could have a demonstration. That's not necessarily asking Parliament for a resolution. They can complain to the ferry company, or they can complain to anyone. Just complain. You could have loads of people walking down the street coming into a town, gypsies, and you could like make a demonstration to stop them if you don't want them in the town. You could just be saying to those gypsies, stop. That's a demonstration. Sunak is breaking the law of England, the law and rules of England. Sunak Patel and the police force have been updated on this. The police force have been updated on the law and the legislation and the rules. And because of that new bill gone through in Scotland about hate speech and so forth, I don't know how the Mayor of London, Sadiq Khan, I don't know how he has managed to get the police to go and do that. The police don't know the law. And I know they don't know the law because Max Hill, the Director of Public Prosecutions, didn't even know the law when someone painted a wall. When there's two full acts of law that describe that how you do it and what law you use to do it, and that's the same enactment you use that removes you from that statutory instrument. Anyway, we've got these police are criminals. These police are now, it's a perversion of the course of justice. It is a perversion of justice. What other sections are there? Section 42s. Persons committing any common assault. Well, that's the same we just looked. Common assault. Assault. This section 42 is just coming up with all these assaults. It has to be that one that I read about section 43. Section 42, Armed Forces Act. A person subject to service law or civilian subject to service discipline commits an offence under this section if he does any act that is punishable by the law of England or Wales, or if done in England or Wales would be so punishable. A person subject to service law or a civilian subject to service discipline commits an offence. A person will be charged with an offence under this section even if he could on the same fact be charged with a different service offence. Person guilty of an offence under this section is liable to the corresponding officer under the law of England and Wales is under that law an offence punishable with imprisonment. Any punishment mentioned in the table in 146. Armed forces. I wonder if those police were armed. Well, they are armed. They're always armed because they've got truncheons, handcuffs, sergeant at mace. Sergeant at mace. They used to be called sergeants at mace. I've been researching it. The truncheons are always a mace, so they're always armed. A police officer is always armed, even if he's not armed with a gun, because he's a sergeant at mace. This is an offence. They're actually committing service offences. And it's imprisonable. It's actually imprisonable. Look at this. Criminal conduct, section 42 of the Armed Forces Act. Subject to service law. They're actually being harassed by the police. What the police are doing is the police intimidating and threatening them with an arrest when they haven't committed, when they actually have got immunity. They're using an enactment which says they cannot be prosecuted, and all of the subscribed peers have supported that cause and signed to it. They've got immunity. And the police are coming in. Who's going to hear the case in the court? The peers. This is crime, you know. Criminal conduct. These are criminal conduct offences. It's Armed Forces Act, yeah. Well, you know, the police are actually always armed with truncheons at mace and handcuffs and possibly tasers as well. Some of them have got tasers. Although I don't think that I don't think they've actually assaulted them yet. If they got the truncheon out and used force, then if they got their Section 42, that means if the police would have used force against them and actually touched them, if the police would have, if Kingsley Hamilton and those protesters would refuse to leave and the police laid a hand on them, like used their taser, actually grabbed hold of their hands with handcuffs, or hit them with their maces, truncheons, that's an offence, because then that's an assault, because they're not committing a crime. It's an assault because they've got a right to be there and they're not breaking any law. So that is crime under this. This is another Section 42. I didn't know that. That brings all this into it as well. You can look at it under here. Criminal conduct offences. So if they hadn't have, well, they voluntarily moved on, I think, but they were, because they were scared. They were being threatened unlawfully. But I think that when they're saying 42, an offence means reasonable offence. Member of the Garda, that's Ireland. It shall be a defence for a person charged with an offence under any of the provisions mentioned in subsection 2 to prove that there was reasonable. That's not opening though. When I click on that, it won't open. Section 42, Hong Kong legislation. Offences against a person that's in Hong Kong. Section 42, the Competition Act. This nexus thing won't open either. A person has got an offence if he intentionally obstructs an officer acting in the exercise of his powers under Section 27. There's a Section 27 if they obstruct an officer, but we've got the Criminal Law Act 1967, which is if you're pursuing a crime or criminals, it's an offence for anyone to obstruct you, even the police, and you don't have to be a police officer yourself. But this is under Section 27, obstructs an officer acting in exercise of their powers. They haven't got any powers. What's this one? This is a 43. That's a terrorism bill. They're not engaging in terrorism. Section 42. Sexual Offences Act, another Section 42. Which act did they do? They read out under Section 42 of what act. These police officers aren't saying what act it is. There's another Section 42 here, assault with intent to commit a sexual offence. This is, like that audit in... Do you know what's happening, right? That audit in Britain made a video the other day, and I watched it. And I watched that some police officers, they literally touched him, sexually assaulted him when he didn't have any reason to be searched at all whatsoever. They touched him sexually, right? And I made a video yesterday about it and put it up. And look, this Section 42's come up here. Assault with intent to commit a sexual offence. That was a police officer the other day with audit in Britain. That's what that police officer did with audit in Britain the other day. Section 42. There's a Section 42 here. Look at that. That was done against audit in Britain the other day. That's Section 42. The police aren't saying which Section 42 it is of which act. So that's for audit in Britain. The audit in Britain needs this. Assault with intent to commit a sexual offence. I need to get the link for it. That's for audit in Britain. But I think that They're doing it under... You can't... Serious organised crime bill. Course of conduct must involve a case of conduct in relation to a single person, conduct at least two. Also, Sadiq Khan is the mayor. He's got a title, and therefore, with that title, he's always in position of counsel, of the Council of London. You can't commit an offence against him if you're doing a political action, because he himself relinquishes... He's got to be available for remonstrations and public actions because of his title. If you're a councillor or mayor, it's a permanent title, and people have got to be able to make addresses to you. And I know some of the Extinction Rebellion people got like a order put on them, so they couldn't go to that MP's house, her own home, to post a letter. But actually, she didn't actually. I think they arrested her, but they let her go. Oh, it was that Phoebe Plummer. Phoebe Plummer went to that MP's house to post a letter, but she'd already got an order on her to keep away. And I'm like, well, no, she's an MP. An MP has to be approachable to give things to. I don't think you can. It's part of the office, the public office. It's part of the public office. But even so, I think they'll let Phoebe Plummer go anyway. Khan's trying to use that, but none of those persons at Extinction Rebellion have got one of those orders on them anyway, even if they had. The person is present outside or in the vicinity of any premises that are used by any individual, the resident, as his dwelling. That person is present there for the purpose, by his presence or otherwise, of representing to the resident or another individual, whether or not one who uses the premises of his dwelling. All right, you might not even be one who uses it, of persuading the resident or such another individual that he should do something that he is entitled or required to do. He should not do something that he's in. Or he should not do something that he's entitled or required to do. This is definitely it. Or that he should do something that he is not under any obligation to do. Right. Well, the people there have a right to do something. But they're getting him to... Oh, they're asking Khan to, in his mayoral position, stop the ULEZ. They're asking him to stop the ULEZ. And only because he is the mayor with title, which he holds that title 24/7, and he's in a position to do it, but they've got a right to ask him to do that. This law is not for political petition protest, particularly when they've actually got signatures in them pursuing it. This is for, like, for example, if you got a massive gang of kids in town who just like Sadiq Khan's the mayor, and they all like stood outside his house and started harassing him just because he's the mayor for a laugh, and wanted to get him to I don't know, pull a pint or something. But then again, Boris Johnson pulled pints as part of his job, but they might not be petitioning for it. Maybe it could be public remonstration. He should do something that he's not under obligation to do. This right. This is not for political things. This is not for actual proper political actions. You could have like someone outside a ferry port, and like someone's car could be broken down, and a lot of people could be outside someone's house. A big group of 20 people, getting them to come out and help push or use their car battery or use their water in the house, and then start harassing them. And they, like, if they don't want to help or if they haven't got any water for the group of people. This is not for a mayor of London who he's the actual decision maker in a political grievance of which people have got a right to get him to do that action through his position as mayor, which is 24/7 position. that he should do something he's not under any obligation to. That person intends his presence to amount to the harassment or cause of distress of the resident, knows or ought to know that his presence is likely to result in harassment. You're going to be harassed all the time if you're the mayor, because you're going to get complaints. No one who, if you want a job as a councillor, you're going to get a lot of complaints, and it's not for people who aren't too keen on complaints, because anyone, the normal average person who is a resident of any town or city or countryside or street or whatever, to the average person, the amount of complaints and grievances that you receive if you choose or want to be a councillor or a MP or even a police officer in public office would to the average person be too much to handle. It would be find it harassment. When that office comes, there's a certain, you've got to accept communications that are reasonably expected to arise. Complaints from multiple persons, petitions from multiple persons, remonstrations because of decisions that you make in the public office. Even if you're at home, you have the office. And the thing is, so what if they're near or close to his house? That's not, what happens if there's only, what happens if they're in, Lowestoft or somewhere? What happens if Khan is the mayor of Pimpleton and it's a small village, like in those charters? He can't, tough. He shouldn't be the mayor. Does it have to have all these? One, a person commits an offence if, and then that person, the presence of the person, amounts to the harassment of or causes alarm, distress. Any person falling within the subsection is likely to. Person falls within the subsection. He is a resident, a person in the resident's dwelling, a person in another dwelling in the vicinity of the resident's dwelling. In another dwelling, but they're outside. They're not the resident. They're not someone in the resident's dwelling, and they're not a person in another dwelling in the vicinity of the dwelling. They're not any of those. The references in subsection 3.1 to a prison, references to his presence, either alone or together with that or another persons who are also present. For the purposes of this section, it ought to know that his presence is likely to result in harassment or cause distress. Person guilty of an offence under this section shall be liable, summary conviction, in relation to commencement of penalties. A constable in uniform may arrest without warrant any person reasonably suspects of committing an offence under this section. Well, yeah, unless they've got a right. Unless they've got the right. Subsection ceases to have effect on the commencement of section 10 of this Act. Harassment is such a police direction to stay away from a person's home. I don't think they're actually near their home. They're in the centre of a town. I don't think you can have that when it's a public remonstration for a political cause. Section 42 of the Criminal Justice Act, police directions, stopping harassment of a person in his home. Requirements may be imposed, direction. A requirement to leave the vicinity of the premises in question. It doesn't have any distance, though. You'll get black belt barrister on this. What is the vicinity? There's no distance. A requirement to leave the vicinity and not return within such period is specified. Not being 3 months. Don't tell me a police officer can just say that without a warrant. I don't think that you can have that for political matters, because what happens if you're going flying the next day? Can we see? Contrary to direction given to him. Yeah, constable given direction, requirement. Let me see, offence, returns premises, person given offence. You got to be found guilty, yeah, but the thing with these offences is you're going to get judged by your peers, by the judgment of your peers, and they don't have peers in the magistrates' court. Unless they go to Crown Court. And anyway, they've got all the peers there. All the peers are there. But they got quite a lot of police to try and scare the peers in their judgment. And actually, they scared them to make them question or doubt that they've got the right. So they're actually, what the police are actually doing, the police are harassing the protesters who can make judgment of what they think is suitable or fit in law, right, for the judgment of the peers, and the police are affecting their judgment. They're actually changing their judgment. Because it's that petition's a lawful due process anyway. That's another thing, for sure. In relation to an offence committed before the commencement of Section 82, this is 2003, racial and religious hate, offences of trespassing on designated site. Why didn't the police, I don't think they ever charged or prosecuted those people who camped outside Khan's house. So if the police didn't do anything then really that could be used as evidence that it isn't an offence, and there wasn't one because they had a perfect opportunity to do it and they allowed them on another occasion doing the same thing anyway. It is a defence for a person charged with an offence under this section to prove that he did not know or no reasonable cause to suspect that the site in relation to which the offence alleged was a designated site. A person guilty of an offence under this section, imprisonment and proceedings. An offence in section against any person, England or Wales. No proceedings for an offence under this section may be instituted against any person in England or Wales except with the consent of the Attorney General. Well, the Attorney General is the one who normally grants assisting offenders immunity for the police when they've got people on their side helping them. Who's granting the petitioners their indemnity? Well, they grant it themselves, the peers. The police are trying to persuade them. Collecting the signatures is a lawful due process. What the police are doing is it's like intimidating a jury. It's intimidating a jury. It's the equivalent of intimidating a jury. It's on the same level of intimidation. This is a very serious offence that the police are doing, I think. Site means the whole part of any building or buildings or any land or both. Crown. I don't think this is public. I don't actually think you can do this in a public place. I think this vicinity, it didn't give a distance, did it? It said it covered all inside and other buildings adjacent or opposite and inside. And then you've got like your property and private land. I don't think that... I can't see how they can stop people from going to a certain shop or something in public. Duchy interest means an interest belonging to Her Majesty in right of the Duchy of Lancaster. What? Oh, it's Crown land as well. Well, you got the right to petition the King. I guess that's private land though. Well, you can present a petition to the King, so how can you go on there to present it? Surely you can go on there to present it and you don't have to have under 20 people. You've got the right to... They withdrew the offence. They can't have presenting a petition or presenting a petition to the King because they withdrew that offence. It was an offence. They decided to repeal that offence. So when they are doing these petitions, right, they can't say that this is that offence, what they withdrew. Because that offence is specific for petitions and doing petitioning and remonstrations concerning petitions. And that act, not having too many people to present it to the King, they repealed it. And that was the act that concerned petitioning. This one doesn't. This concerns other behaviours and so forth, which are not petitions. Because why didn't they leave the Tumultuous Petitioning Act in place? They haven't done, have they? That act that act proves that there are acts and actions, remonstrations and so forth that are particularly associated with and connected with political actions. And they could have left that there, but they repealed it. So this can't be applicable to those acts and actions, particularly when there's a 1688 Bill of Rights. I won't be surprised if it's Charles who went and dialed through to send the police. The countryside, an order is a designation order is enforced. They haven't got a designation order yet, though, either. Countryside and Rights of Way Act, or rights of public in relation to access land, and part of the Countryside Act, access to open country. Secretary of State may. I don't think this applies. This does not apply to like a town centre with shops, because anyone has a right to go there for normal duties, and it's not considered a harassment, I don't think. Because what about consumer rights and trading standards? If you have to, how can they stop you from going into a shop if you've got to get it fixed? It's a little. This is getting a little bit like Facebook and YouTube when you've got the Public Meetings Act and they were completely denying it. Hey, just a minute. The police are breaking up a meeting. The police are breaking up a meeting, a public meeting, contrary to the Public Meetings Act 1908, and stopping them transacting informations with the public. So they know it wasn't about the harassment of an individual. They were transacting information to the public about stopping ULEZ. And they gave it to meet there. And not only that, they were using the right to petition, which is you use political rights when you have an election meeting. So that's the purpose and reason they were there, to transact the stop the ULEZ to the public. And the police are claiming they were there for a different reason, to harass one person, when it's clearly obvious. Sadiq Khan hasn't got the right to, just because he's near a vicinity, to break up public meetings if he doesn't like them and stop them transacting. This man isn't really in the right job, I don't think. I don't think that he should be the mayor, because that job comes with things like this, people complaining or doing protests. So, it comes with it. Appropriate person is a person appearing to the Secretary of State to have sufficient interest in the building or land to consent to the notice being displayed, steps being taken, person acting on behalf of especially such a designated order means an order. There is no order. They haven't actually got an order. And I don't think that order covers a public place like that, because you can have public meetings. And that public meeting is not for the... If all public meetings were deemed to be harassing people, anyone could call it out. I definitely think the mayor is abusing the act, and the police the police don't have a right there. The police don't have a right there. Section 42 can require a person in his home. Well, the problem is he's in his home and he's not there on the streets. There's no area for the vicinity. This act is not like a public access place of shops and so forth. It's like lands. It's the Crown land. But then again, you can even... I think that Crown section part of it, if you're actually handing a petition in, can even be negated as well. The police really haven't got a clue what they're doing. The case of conducting some person. It's under the Serious Organised Crime and Policing Bill. Organising people to come together for a public meeting to transact with the public over a officially declared matter is not serious organised crime, and it never can be, because it's a lawful due process. It's a lawful due process, and it's designated as a lawful due process because they're going about it by collecting the signatures. This cannot apply to a lawful due process of law, because really those police officers are intimidating people who are engaged in a legal proceeding. It is like intimidating a jury. But also, that's interesting about the weapons. If they'd have used force against them and got weapons out, it still is harassment. The police are harassing them. Actually, the police are guilty of that offence, but it's in public. So I think the police, firstly, they're perverting the course of justice. Secondly, if they'd have got actually their mace arms out, their truncheons, handcuffs or tasers, when those people were engaged in a public meeting through a lawful due process prescribed by law, that would have been also quite a serious assault under that other act as well. So I'm glad I found that other offence as well. I'm glad I found that other section offence. It's called the same section, but it's in a different act. It's under the same number. Sexual assault. That's what happened to Audit in Britain the other day.